Good morning, everyone. I've chosen to share with you today a recent ruling on pregnancy-related discrimination. And the reason I've chosen to share it is because it's amusing in a sad way, because of the actions of the employer are basically so bad that it's a masterclass in how to get it wrong, which for everybody else is positive tips as to how to get it right. So it hinges around a case which was held in May of this year, and it was an employment tribunal case between Miss Kimberly, and Calibre Building Services. Now, if we look at the chronology of the events, basically she goes for an interview on the 8th of June as a contracts administrator, and she's offered the role the same day, and she accepts the role. And she agrees that she will start on the 20th of June. Now, 5 days before she starts the role, she finds out that she is pregnant. And her immediate response was to ring the agency who had made the placement and to ask if she was still okay to start work. And the agency said, go ahead and start. And she started on the 20th of June without disclosing her pregnancy to her new employer. Now, the reason that this is interesting is that I'm sure many of you in this room will have been in this situation where you will have had someone who is about to start who becomes pregnant or starts and immediately afterwards informs you that they're pregnant. And as an employer, much as you should grit your teeth and say, congratulations, that's fabulous news, your immediate response is, oh, I've just recruited someone for this role and now they're going to go off for a period of time. So the agency did what they should have done, allowed her to start. She started work. She didn't disclose the pregnancy. And then in July, she goes out clothes shopping with a couple of colleagues and they start talking about, does this suit me? Doesn't this suit me? And one of them says, well, because she's already confided in one of them. And one of them says, well, I don't think that'll be any good for you. You won't be able to wear it for long in your condition. So immediately another colleague finds out about it. But all this time, she hasn't told her line manager, the office manager. So the 25th of July, time moves on, 25th of July, Mrs. K, she meets Miss Lowe, the office manager, and she tells her about the pregnancy. And at that point, she's 12 weeks pregnant. So Miss L, Miss Lowe, the office manager, immediately stops the meeting and was surprised by the news. I think disappointed is probably the word, and responds that she didn't know what effect the news would have on her employment and what the implications would be for her continuing employment, which is obviously mistake number one. Mistake number two, she then gets onto the agency immediately, and I know we have agencies in the room, so some of you will have dealt with this, and she starts complaining bitterly about the fact that they have placed this woman with her when she deliberately asked for someone who would have at least 12 to 18 months longevity in the role. So complains and complains, then gets onto HR, who presumably calm her down and tell her to behave, and then resumes the meeting. Now, the facts about the meeting which resumed were heavily disputed in the employment tribunal. This is the bit that was quite amusing in a sad way, really. But it goes along the lines of, why couldn't she have been more careful? And she really should have used contraception. And having covered that ground, which she obviously shouldn't have covered with her, surprisingly, the meeting ends really well. And it ends with the two ladies hugging and going their separate ways. So presumably the line manager had been told to pull it round a bit, and apparently she'd empathised with her on the grounds that she too had experienced an unplanned pregnancy. So they hugged, went on, and apparently, according to the tribunal transcript, which is very long, they continued to have a good social relationship, so there was no animosity in the workplace. However, as time went on, and this is something that you will have all come across. I mean, I'm sure many of you will have had an employee where you think there are some performance issues, you really should get round to tackling them. You perhaps don't get round to tackling them, And then the next thing, the employee announces that they're pregnant, and then you suddenly think, actually, I can't tackle them. Well, in August and September, there were concerns expressed about this lady's performance at work, and I think they were highlighted when she was off on holiday, that they uncovered a few things which weren't really going to plan. Also in August, Kimberly stated that she'd work until her February due date, and there was some discussion about that, following which she later on asked to move her start date for maternity to the December. But they held a meeting in September, and they said basically they thought it was appropriate to extend her probationary period. Now, at that point, that was accepted by Kimberly because they gave examples of what it was she was doing well, what she could be doing better. Apparently she was great on the phone, but her admin needed to be improved upon. So she accepted all that. They extended the probationary period. However, this is where it goes worse, if you like. In December, they have a further meeting to review performance on the basis of the objectives that they'd set for her. And in that meeting, they decide that they need to extend it for a second time because it's still not going to plan. And they say at this point they will extend it to her return from maternity leave. But that wasn't all that was said in the meeting. Apparently, during that meeting, Miss Lowe, the line manager, got very angry and agitated about what she perceived to be Kimberly's lying about the fact that she was pregnant, withholding it from them. Not that it was relevant at all, but basically had a go at her during the meeting and said, you've been lying to me, you let other people know first, and actually you knew about the pregnancy before you started. So, that was unethical. The events of this meeting were heavily disputed. But what also came out of it was that following the meeting, Miss Lowe, the line manager, was so angry with the agency that she went out and wrote a letter to them. So you can't beat a bit of hard evidence here to bring in front of the tribunal, which says, I have been made aware of the advice you directly gave Charlotte Kimberly, which I find to be totally unethical, and that you've taken monies from Calibre under false pretenses. So she basically says to the agency, you've taken our money and lied to us. All of which played into the hands of Mrs. Kimberly when she took it to tribunal. So basically the judgment on this case was not a favourable one for the employer. The tribunal accepted that the recruitment agency had been heavily criticised, and Miss Kimberly was told that she caused disappointment. There was the fact that Miss Lowe had also written to the agency to express her disappointment, which obviously suggested that had she known about the pregnancy, she would not have taken that person on. So it suggested that discrimination was going to take place in any event. They also found that her alleged accusations in this meeting of the 20th of December were unfavourable treatment, because apparently it's alleged that she said she should be ashamed of herself. Not really the way to treat a pregnant employee in any event. They found actually that Calibre, the company, did have legitimate concerns about the performance. So they were justified in dealing with the performance complaints, but it was the way they went about them. And in particular, that second extension of the probationary period was found to be discriminatory because it was purely linked to the pregnancy. And that was given legs by the fact that they launched an attack on her about withholding details of the pregnancy. So basically the finding is that obviously under the Equality Act, a woman cannot be discriminated against for anything in relation to her pregnancy or subjected to detriment. So that would apply not only to if you are recruiting someone into a role, but also if you're affording them some other opportunity, such as promotion. So what can we learn from this? Well, I'm sure you could give me a list from what I've just said, but the basics are that a woman is not obliged to disclose her pregnancy to you, even if she's coming for a role which constitutes maternity cover. She does not have to tell you. You are not able to ask. The second thing that comes out of it is that you cannot engage a third party, such as a recruitment agency, to discriminate on your behalf, which was effectively what Calibre Building Services were trying to do here. what they tried to do was put pressure on the agency in terms of saying, you know, we must have 12 to 18 months out of that person, which from a legal perspective is wrong. But obviously from a practical perspective, who knows anyway what could happen to somebody in a 12 to 18 month period. So for the employers out there, it is really not worth trying to put your neck on the line by getting somebody else to do the discrimination for you. And if you are going to attempt to do that, don't reinforce it by giving written evidence. Other basic things, she really shouldn't have talked about contraception. If someone comes to you and says, I'm pregnant, I've got some news, I'm pregnant, and even if they're saying, oh, you're not going to be very happy because I'm going to be off, the first thing you say is, congratulations. And you smile, and then you say, I'm going to write you a letter which will explain to you all the things that you need to know about your pregnancy and all your rights and entitlements. And even if you're actually inwardly seething because of the inconvenience it's caused to you, that's all you do. You say, I'll come back to you, you shut the door and you move away. You don't go ranting and raving and about liars and unethical treatment. And some other basic things there as well. You know, it's fine to be empathetic with people, but perhaps there was a bit of oversharing that went on, and you certainly don't talk about contraception. And maybe the hug wasn't such a good idea, because although it wasn't actually used against her, it could easily have been done so. So the final point on this is, it is not a problem to deal with performance issues for a pregnant employee. They do enjoy protection. Sorry. Or maybe not. Employment protection. But what you really need to think about is, if you have an issue with somebody, that you deal with everybody fairly. And if you have performance issues at the outset, you get on and deal with them. Because if you're dealing with performance issues and subsequently someone comes to you and says, and actually I'm pregnant, that doesn't mean that you stop it, because that's unfair to every other employee who isn't. It just means that you already have a marker down for what you're dealing with. I know lots of people get very scared about dealing with performance in any context. And as the others have said, if you've got a problem of this type, because it is quite fraught and you can easily fall into pitfalls, you really should give us a ring. So I hope that that's given you a few pointers as to what to do. It's congratulations, smile, I'll be writing to you.